Pavlovich versus Superior Court on page 76 of the California Civil Procedure Handbook, Rules, Selected Statutes and Cases, and Comparative Analysis, Chapter 4, the proper court, Subpart B, the personal jurisdiction section. We're talking about general and specific. And this is part 3 of that section, due process, the effects test. Justice Brown gave the opinion in 2002, the so-called internet revolution has spawned a host of new legal issues as courts have struggled to apply traditional legal frameworks to this new communication medium. Today, we join the struggle and consider the impact of the internet on the determination of personal jurisdiction. In this case, the California court exercised personal jurisdiction over a defendant based on a posting on the internet website. Under the particular facts of this case, we conclude the court's exercise of jurisdiction was improper. Subpart 1. Digital versatile discs, DVDs, provide high-quality images such as motion pictures digitally formatted on a convenient 5-inch disc. Before the commercial release of DVDs containing motion pictures, the Content Scrambling System, CSS, a system used to encrypt and protect copyrighted motion pictures on DVDs, was developed. The CSS technology prevents the playing or copying of copyrighted motion pictures on DVDs without the algorithms and keys necessary to decrypt the data stored on the disc. Plaintiffs, DVD Copy Control Association, Inc., that's DVD CCA, is a nonprofit trade association organized under the laws of the state of Delaware with its principal place of business in California. The DVD industry created DVD CCA in December of 1998 to control and administer licensing of the CSS technology. In September 1999, DVD CCA hired its staff and in December acquired the licensing rights to the CSS technology and became the sole licensing entity for this technology in the DVD video format. Defendant Matthew Pavlovich is currently a resident of Texas and the president of Media Driver LLC, a technology consulting company in Texas. Pavlovich does not reside or work in California. He has never had a place of business, telephone listing, or bank account in California and has never owned property in California. Neither Pavlovich nor his company has solicited any business in California or has any business contacts in California. Pavlovich was the founder and project leader of the Livid video project. Livid, which operated a website located on livid.on.openprojects.net. The site was only provided information, did not solicit or transact any business or permitted no interactive exchange of information. Between its operators and visitors. According to Pavlovich, the goal of Livid was to improve video and DVD support for Linux and to combine the resources and the efforts of the various individuals that were working on related things. To reach this goal, the project sought to defeat the CSS technology and enable the decryption and copying of DVDs containing motion pictures. Consistent with these efforts, Livid posted the source code of a program named DCSS on its website as early as October 1999. DCSS allows users to circumvent the CSS technology by decrypting data contained on DVDs and enabling the placement of this decrypted data on computer hard drives or other storage media. At the time Livid posted DCSS, Pavlovich knew that DCSS was derived from CSS algorithms and that reverse engineering of these algorithms was probably illegal. He had also heard that there was an organization which you had to file for or apply for a license to the CSS technology. He did not, however, learn that the organization was DVDCCA or that DVDCCA had its principal place of business in California until after DVDCCA filed this action. In its complaint, DVDCSA alleged that Pavlovich misappropriated its trade secrets by posting the DCSS program on the Livid website The plaintiff sought injunctive relief but did not seek monetary damages. In response, Pavlovich filed a motion to quash service of process contending that California lacked jurisdiction over his person. DVD CCA opposed, contending that jurisdiction was proper because Pavlovich misappropriated DVDs, CCA's trade secrets, knowing that such would be adversely impact an array of substantial California business enterprises, including the motion picture industry, the consumer electronics industry, and the computer industry. In a brief order, the trial court denied Pavlovich's motion, citing Calder v. Jones, 1984, and Panavision in turn, LP v. Topin, 9th Circuit heard in 1998. Pavlovich petitioned the Court of Appeals for a writ of mandate. The Court of Appeal issued a published opinion denying the petition because Pavlovich knew that posting DCSS on the Livid website would harm the movie and computer industries in California, because the reach of the internet is also the reach of the extension of the poster's presence. The internet is also... The court found that he purposely availed himself of foreign benefits under the Calder effects test. The court also concluded that exercise of jurisdiction over Pavlovich was reasonable. We granted review to determine whether the trial court properly exercised jurisdiction over Pavlovich's person based solely on the posting of the DCSS source code on the Livid website. We conclude that it did not. California courts may exercise personal jurisdiction on any business consistent with the constitutions of California and the United States Code of Civil Procedure 410.10. The exercise of jurisdiction over a non-resident defendant comports with these constitutions. The defendant has such minimum contacts with the state that the assertion of jurisdiction does not violate traditional notions of fair play and substantial justice. And it quotes Vaughn's Companies, Inc. versus Seabest Foods, Inc. And also International Shoe versus Washington, which is like another seminal case on minimum contacts. Which means that Burger King stands for purposeful availment, and International Shoe stands for minimum contact, I think. So, the court may exercise specific jurisdiction over a non-resident defendant only if the defendant has purposefully availed himself or herself of foreign benefits from Vaughn's. The controversy is relating to or arising out of the defendant's contacts with the forum, quoting Helicopteros Supra, and the assertion of personal jurisdiction would comport with fair play and substantial justice from Vaughn's, quoting Burger King. In the defamation contest, the United States Supreme Court has described an effects test for determining purposeful availment. In Calder, a reporter in Florida wrote an article for the National Enquirer about Shirley Jones, a well-known actress who lived and worked in California. The president and editor of the National Enquirer reviewed and approved the article, and the National Enquirer published the article. Jones sued, among others, the reporter and editor, individual defendants for libel in California. The individual defendants moved to quash service or process, contending they lacked minimum contacts with California. So that's the case that I just briefed instead of the Hustler case. Okay, so the United States Supreme Court disagreed and held that, I think Hustler was in New Hampshire, where defamation was a cause of action. The United States Supreme Court disagreed and held that California could exercise jurisdiction over the individual defendants based on the effects of their Florida conduct in California. The court found jurisdiction proper because California was the focal point both of the story and the harm suffered. The allegedly libelous story concerned the California activities of the California resident. It impugned the professionalism of the entertainer whose television career was centered in California, and the brunt of the harm, in terms both of Jones's emotional distress and the injury of her professional reputation, was suffered in California. So it's not just that intent. It's like tortious intent directed at the forum state, if I remember correctly. But the court also noted that the individual defendants wrote or edited an article that they knew would have a potentially devastating impact on Jones, and they knew that the brunt of the injury would be felt in Jones in the state in which she lives and works, and which the National Enquirer has its largest circulation. So it was not using the word intent here, but it was directed at. Although Calder involved a libel claim, courts have applied the effects test to other international torts, including business torts, or intentional torts, I should say, including business torts. See IMO Industries Inc. vs. Kikert AG of 1998. Courts must consider Calder in intentional tort cases. Application of the test was, however, been less than uniform. Indeed, courts have struggled somewhat with Calder's import, recognizing that the case cannot stand for the broad proposition that a foreign act with foreseeable effects in the forum state always gives rise to specific jurisdiction, from Bancroft and Masters Inc. vs. Augusta National Inc. 2000. Despite this struggle, most courts agree that merely asserting that a defendant knew or should have known that his intentional acts would cause harm in the forum state is not enough to establish jurisdiction under the effects test. Indeed, virtually every jurisdiction has held that the Calder effects test requires intentional conduct expressly aimed at or targeting the forum state, in addition to the defendant's knowledge that the intentional conduct would cause harm in the forum. We join those jurisdictions that require additional evidence of express aiming or intentional targeting. We now consider whether Pavlovich's context with California meet the effects test. The plaintiff has the initial burden of demonstrating facts justifying the exercise of jurisdiction. See Vons. If the plaintiff meets this initial burden, then the defendant has the burden of demonstrating that the exercise of jurisdiction would be unreasonable. In reviewing a trial court's determination of jurisdiction, we will not disturb the court's factual determinations if supported by substantial evidence. When no conflict in the evidence exists, however, the question of jurisdiction is purely one of law, and of reviewing the court engages in an independent review of the record. Applying these standards, we conclude that the evidence in the record fails to show that Pavlovich expressly aimed his tortious contact at or intentionally targeted California. In this case, Pavlovich's sole contact with California is Livid's posting of the DCSS source code containing the DCCA's proprietary information on the internet website accessible to any person with internet access. Pavlovich never worked in California. He owned no property in California, maintained no bank accounts in California, had no telephone listings in California. Neither Pavlovich nor his company solicited or transacted any business in California. The record also contains no evidence of any Livid contacts with California. Although we have never considered the scope of personal jurisdiction based solely on internet use, other courts have considered the issue, and most have adopted a sliding scale analysis. That's right. And we go to the Zippo case a little bit later in this paragraph. At one end of the spectrum are situations where the defendant clearly does business over the internet. If the defendant enters into contracts with residents of a foreign jurisdiction that involve the knowing and repeated transmission of computer files over the internet, personal jurisdiction is proper. At the opposite end are situations where the defendant has simply posted information on an internet website which is accessible to users in foreign jurisdictions. A passive website that does a little more than make information available to those who are interested in it is not grounds for the exercise of personal jurisdiction. The middle ground is occupied by interactive websites where a user can exchange information with a host computer. In these cases, the exercise of jurisdiction is determined by examining the level of interactivity and commercial nature of the exchange of information which occurs on the web, and that's from Zippo. So we got interactive, and we've got, what are the other ends? Knowing and repeated is one end, and on the other end it's passive. So it's probably active and passive. Zippo Manufacturing Co. versus Zippo.com Inc. Here, Livid's website merely posts information that has no interactive features. There is no evidence in the record suggesting that the site targeted California. Indeed, there is no evidence that any California resident ever visited, much less downloaded the DCSS source code from the Livid website. Thus, Pavlovich's alleged conduct in posting a passive website on the internet is not by itself sufficient to subject him to jurisdiction in California. Jewish Defense Organization versus Superior Court of 1999. Refusing to exercise jurisdiction under the effects test, even though the defendant had passive websites on the internet, refusing to exercise jurisdiction under the effects test, even though the defendant posted infringing material on his website. Created a site, like placing a product into the stream of commerce, may be felt nationwide or even worldwide, but without more, it is not an act purposely directed at or even toward the forum state. Cybercell Inc. versus Cybercell Inc. Quoting Ben Susan Restaurant Corp. versus King, New York case in 1996. Cybercell was the Ninth Circuit in 1997. Otherwise, personal jurisdiction in internet-related cases would almost always be found in any forum in the country. Such a result would violate long-held and inviolate principles of personal jurisdiction. Nonetheless, DVDCCA contends posting the misappropriated source code in the internet website is sufficient to establish purposeful availment in this case because Pavlovich knew the posting would harm not only a licensing entity but also the motion picture, computer, and consumer electronics industries centered in California. According to DVDCCA, this knowledge establishes that Pavlovich intentionally targeted California and is sufficient to confer jurisdiction under the Calder effects test. Although the question is close, we disagree. As an initial matter, DVDCCA's reliance on Pavlovich's awareness that the entity owned the licensing rights to CSS technology is misplaced. Although Pavlovich knew about this entity, he did not know that DVDCCA was that entity or that DVDCCA's primary place of business was California until after the filing of the lawsuit. More importantly, Pavlovich could not have known this information when he allegedly posted the misappropriated code in October 1999 because DVDCCA had only begun administering licenses to the CSS technology in December of 1999, approximately 2 months later. Thus, even assuming Pavlovich should have determined who the licensor was and where the licensor resided before he posted the misappropriated code, he would not have discovered that DVDCCA was the licensor. Because Pavlovich could not have known that his tortious conduct would harm DVDCCA in California when the misappropriated code was first posted, his knowledge of the existence of a licensing entity cannot establish express aiming at California. Thus, the only question in this case is whether Pavlovich acknowledged that his tortious conduct would harm certain industries centered in California, i.e. the motion picture, computer, and consumer electronics industry, is sufficient to establish express aiming at California. As explained below, we conclude that this knowledge by itself cannot establish purposeful availment under the effects test. First, Pavlovich's knowledge of the CSS could be used to illegally pirate copyrighted motion pictures on DVDs when that such pirating would harm the motion picture industry in California does not satisfy the express aiming requirement. As an initial matter, the question whether the effects are even related to our analysis because DVD CCS does not assert a cause of action premised on the illegal pirating of copyrighted motion pictures. In any event, the mere unilateral activity of those who claim some relationship with a non-resident defendant cannot satisfy the requirement of contact with form of the state. Worldwide Volkswagen Supra. Thus, the foreseeability that third parties may use DCSS to harm the motion picture industry itself cannot by itself satisfy the express aiming requirement, because nothing in the record suggests that Pavlovich encouraged website visitors to use DCSS to illegally pirate copyrighted motion pictures. His mere awareness they might do so does not show purposeful availment. Second, Pavlovich's knowledge of the effects of his tortious conduct on the consumer electronics and computer industry center in California is an even more attenuated basis for jurisdiction. According to the DVD CCA, Pavlovich knew that posting DCSS would harm the consumer electronics and computer industries in California because many licenses of the CSS technology reside in California. The record, however, indicates that Pavlovich did not know that any DVD CCA licenses reside in California. At most, the record established that Pavlovich should have guessed that these licenses reside in California because there are many consumer electronic and computer companies in California. DVD CCA's argument, therefore, boils down to the following syllogism. Jurisdiction exists solely because Pavlovich's tortious conduct had a foreseeable effect in California, but mere foreseeability is not enough for jurisdiction. Otherwise, the commission of any intentional tort affecting industries in California would be subject to defendant to jurisdiction in California. We decline to adopt such an expansive interpretation of the effects test. Indeed, such a broad interpretation of the effects test would effectively eliminate the purposeful availment requirement in the intentional tort context for the select plaintiffs. In most, if not all, intentional tort cases, the defendant is or should be aware of the industries that may be affected by his tortious conduct. Consequently, any plaintiff connected to industries centered in California, i.e. motion picture, computer, and consumer electronics industries, could sue an out-of-state defendant in California for intentional torts that may harm those industries. For example, any creator or purveyor of technology that enables copying of movies or computer software, including a student in Australia who develops a program for creating backup copies of software and distributes it to some of his classmates, or a store owner in Africa who sells a device that makes digital copies of movies on videotape, would be subject to suit in California because they should have known their conduct may harm the motion picture or computer industries in California. Indeed, the DVD CCA's interpretation would subject any defendant who commits an intentional tort affecting the motion picture, computer, or consumer electronics industries to jurisdiction in California, even if the plaintiff was not a California resident. Under this logic, plaintiff's connection to the auto industry could sue any defendant in Michigan. Plaintiffs connected to the financial industry could sue any defendant in New York. The plaintiffs connected to the potato industry could be sued by any defendant in Idaho. Because finding jurisdiction under the facts in this case would effectively subject all intentional tortfeasors to conduct may harm industries in California, jurisdiction in California declined to do so. We, however, emphasize the narrowness of our decision. The defendant's knowledge that his tortious conduct may harm industries centered in California is undoubtedly relevant to any determination of personal jurisdiction and may support a finding of jurisdiction. We merely hold that this knowledge alone is insufficient to establish express aiming at the forum state as required by the effects test, because the only evidence in the record even suggesting express aiming of Pavlovich's knowledge that his conduct may harm industry centered in California due process requires us to decline jurisdiction over his person. In addition, we are not confronted with a situation where the plaintiff has no other forum to pursue its claims and therefore do not address that situation. DVD CCA has the ability and resources to pursue Pavlovich in another forum such as Indiana or Texas. Our decision today does not foreclose it from doing so. Pavlovich may still face the music, just not in California. Accordingly, we reverse this judgment of the Court of Appeal and remand for further proceedings consistent with this opinion. And who concurs is Kennard, Werdiger, and Moreno. Justice Baxter dissents. I respectively dissent that this case involves a powerful new medium of electronic communication usable for good or ill should not blind us to the essential facts and principles. The record indicates that by intentionally posting an unlicensed decryption code for the content scrambling system, CSS, on the internet websites, defendant and his network of open source associates sought to undermine and defeat the very purposes of the licensed CSS encryption technology, for example, copyright protection for movies recorded on digital versatile discs, DVDs, and limitation of playback to operating systems licensed to unscramble an encryption code. The intended targets of this effort were not individual persons or businesses, but entire industries. Defendant knew at least two of the intended targets: the movie industry and the computer industry involved in producing and licensed playback systems. Either were centered in California or maintained a particularly substantial presence here. Thus, the record amply supports the trial court's conclusion for purposes of specific personal jurisdiction that defendant's intentional act, even if committed outside California, was expressly aimed at California, citing Calder v. Jones. In the particular circumstances, it cannot matter that defendant may not have known or cared about the exact identities or precise locations of each individual target, or that he happened to employ a so-called passive internet website, and whether any California resident visited the site. By acting with a broad intent to harm industries he knew were centered or substantially present in the state, defendant forged sufficient minimum context of California that he should reasonably anticipate being hailed. That's Burger King's. Reasonably anticipated being hailed into court here. No, that's Worldwide Volkswagen Corp versus Woodson. Reasonably foresee being hailed into court. For litigation arising out of his forum-related conduct, citing Vons. The majority ascribe undue significance to the fact that Pavlovich acted through a new and rapidly burgeoning medium of interstate and international communication, the internet. They assert that the mere posting of information on a passive internet site, which is accessible from anywhere but is directed at no particular audience, cannot be the action targeted at a particular forum. Otherwise, they worry mere use of the internet would subject the user to personal jurisdiction in any forum where the site was accessible. I agree that mere operation of an internet site cannot expose the operator to suit in any jurisdiction where the site's contents might be read or where resulting injury might occur. Communication by a universally accessible internet website cannot be equated with express aiming at the entire world. However, defendants who aim conduct at particular jurisdictions, expecting and intending that injurious effects will be felt in those specific places, cannot shield themselves from suit simply by using the internet or some other generalized medium of communication as a means of inflicting harm. Quoting Calder, significant California circulation of nationwide newspapers supports California defamation suit by California resident against Florida residents who wrote and edited defamatory article. Keaton vs. Hustler magazine, cited here for significant regular circulation of nationwide magazine in New Hampshire, supports New Hampshire's defamation suit against magazine by a well-known New York resident. In such circumstances, the defendant is not exposed to universal and unpredictable jurisdiction. He faces suit only in a particular forum where he directed his injurious conduct and where he must reasonably anticipate being called into account. It is true that one cannot be sued in another forum simply because his or her conduct has foreseeable effects there. A number of lower court decisions suggest further that absent other indicia of activity purposely directed at the forum, even the defendant's intent to injure a forum resident standing alone is not sufficient to satisfy the test of Calder. In several cases, have held that alleged trademark infringement on an internet website alone cannot, under Calder, establish a minimum context of the forum in which the trademark owner resides. Nonetheless, I believe that the unusual and unprecedented facts of this case demonstrate purposeful activity directed toward the forum sufficient to establish minimum conduct under the Calder test. As a result of his actions, defendant Pavlovich should reasonably have anticipated being hailed into court in the state, and recognition of California's jurisdiction thus meets the constitutional standards of fairness. The posting of the DCSS source code on Pavlovich's Livid website was done with the specific goal of negating by illegal means the licensed CSS technology Pavlovich knew had been jointly developed by the movie and DVD industries for the mutual protection. Pavlovich's immediate aim, he acknowledged, was to promote development of the alternative DVD playback systems not dependent on CSS licensor. However, he also knew CSS was intended to afford crucial copyright protection to DVD movies. He has denied any personal desire to pirate movies or to encourage others to do so, but by declining to display the DCSS source code without restriction on the universally accessible website. Pavlovich offered visitors to the site the patent opportunity to exploit this information as they choose. By taking this calculated action, Pavlovich thus not only foresaw, but must have intended, the natural and probable consequences he knew would befall the affected industries. These consequences included both the competitive injury Pavlovich admitted he intended to inflict upon the DVD industry, which is substantially present in California, and the loss of copyright protection to the movie industry he knew was primarily associated with this state. His lawsuit, brought by the agent of these affected industries, seeks to forestall just such damage by enjoining Pavlovich and other members of his network from continuing to display the DCSS source code on their website. Civ Code Section 3426.2, Subdivision A. For purposes of such an action, it is irrelevant whether Pavlovich himself exploited DCSS for commercial benefit. The instant suit is predicated on the inherent harm to California-centered industries caused by Pavlovich's intentional, knowing, and allegedly improper disclosure of their trade secret. Pavlovich knew he was targeting those industries when he acted. He proceeded despite his assumption that DCSS was likely illegal. He thus had every reason to expect, indeed, he effectively invited responsive litigation. For purposes of this particular action, therefore, he established sufficient connection with the state that he must reasonably anticipate being hailed into California court to account for his conduct. Citing Worldwide Volkswagen and Burger King. Because of the minimum context he forged by his intentional conduct directed towards the state, maintenance of a related suit against him in this form does not offend traditional notions of fair play and substantial justice from Calder and International Shoe. I see no reason why the result should differ simply because Pavlovich targeted entire industries within the forum rather than a single individual business. The majority suggests there is no case where a court exercised jurisdiction under the effects test based solely on the defendant's knowledge of industry-wide effects in the forum state. By the same token, however, no decision has held that the defendant's efforts to target an entire industry cannot form a basis for specific personal jurisdiction. It's getting to be rather long. Jurisdiction is appropriate under Calder whenever a foreign defendant expressly aimed injurious actions toward the forum with the intent and understanding that the brunt of the harm would be felt there. Calder, while targeting an individual forum resident, certainly meets that test. The aiming is no less specific and jurisdiction no less proper when the effort is directed with equal purpose and precision at one or more entire industries located there. Nor, in my view, is it fatal that individual members of the industries Pavlovich targeted are not based exclusively within California. When, as here, one purposely directs injurious conduct against entire industries with actual knowledge that they are primarily or substantially present in a particular forum, his contacts with that state are no more attenuated, random, or fortuitous than if, by unusual happenstance, they were solely concentrated there. The actor must reasonably anticipate that litigation generated by his intentional conduct will originate in a forum where, as he knows, the industry or industries sought to injure are primarily or substantially located. Otherwise, one who acted from a remote location against an entire multi-state or multinational industry as opposed to a single enterprise could rest secure that he was immune from suit in every jurisdiction where members of that industry were located. Indeed, that is an unfortunate result and a glaring flaw of the majority's holding. Under the majority's rule, the California Senate industries directly targeted by Pavlovich and his numerous internet colleagues have no recourse for their alleged injury but to pursue a multiplicity of individual suits against each defendant in his or her separate domicile. Nothing in the basic principles of long-arm jurisdiction compels such an illogical and unfair outcome. I therefore conclude that Pavlovich purposely established minimum contacts with California sufficient to permit litigation related to those contacts to proceed against him here. Of course, once it has been decided that the defendant purposely established minimum contacts within the form state, these contacts must be considered in light of other factors to determine whether the assertion of personal jurisdiction would comport with fair play and substantial justice. The courts, in appropriate cases, may evaluate the burden on the defendant, the forum state's interest in adjudicating the dispute, the plaintiff's interest in obtaining convenient and effective relief, the interstate judicial system's interest in obtaining the most efficient resolution of controversies, and the shared interests of the several states in furthering fundamental substantive social policies, and that comes from Burger King and Ashy Metal Industry. And so that's a factorial test for fair play and substantial justice. And you saw the facts were the burden on the defendant, the forum state's interest, the plaintiff's interest in convenient and effective relief, the interstate judicial system's interest in obtaining the most efficient resolution of controversies, and the shared interests of the several states in furthering fundamental substantive social policies. So I think it's a 5-factor test. These considerations sometimes serve to establish the reasonableness of jurisdiction upon a lesser showing of minimum contacts than would otherwise be required. Moreover, where a defendant who purposefully has directed his activities at forum residents seeks to defeat jurisdiction, he must present a compelling case that the presence of some other considerations would render jurisdiction unreasonable. Although Pavlovich argues otherwise, he has failed to make such a compelling case here. On the contrary, as the Court of Appeal concluded, the factors bearing on the overall reasonableness of California jurisdiction weigh strongly on the side of such jurisdiction. The first of these factors, the burden on the defendant. Okay, and we're going to break down those factors, it looks like. Yeah. So I'm just skimming the factorial analysis in further detail. Hopefully in real life I never have to make these arguments. Constitutionally fair and reasonable is where we arrive at after that proposed factorial analysis by the dissenting opinion. Last paragraph, though the majority imply otherwise, the result I propose does not signal a broad new rule that California jurisdiction is proper over any foreign defendant who causes foreseeable effects in the state. On the contrary, I base my conclusions on the specific facts of this case. These facts indicate that defendant Pavlovich engaged in intentional conduct, purposely targeted the interests he knew were centered and substantially present in California, with knowledge that they would suffer harm here, such that he must reasonably have anticipated being called to account in this state. Pavlovich thus forged minimum contacts with California, and it is otherwise fair and reasonable to assert personal jurisdiction over him here for purposes of related litigation. For these reasons, and these reasons alone, I conclude that this motion to quash was properly denied. I would affirm the judgment in the Court of Appeal. We concur, George and Chin. So notes and questions regarding Pavlovich and the effects test. 1. The Pavlovich majority emphasized that its purposeful availment decision was a narrow one based on the particular facts in this case. What factual changes might cause the majority to conclude that defendant Pavlovich had expressly aimed his tortious conduct at or intentionally targeted California? What if Pavlovich had, in fact, received the cease and desist letter from the Motion Picture Association referred to in footnote 4 before he posted a misappropriated code on his website? And how could he? So what if Pavlovich had known DVD CCA was the entity that owned the licensing rights to CSS technology before he posted the misappropriate code? What if he also knew that their principal place of business was in California, or he knew DVD CCA's licenses reside in California? And I think that's relevant, honestly. To target entire industry is absurd. But if it's directed at a particular business or association, that's a different story. So 2, defendant Pavlovich's knowledge at the time he posted the misappropriated code on the website was very important to the court in determining whether he expressly aimed to target California within the meaning of the effects test. Should this inquiry into the defendant's knowledge be based on subjective, i.e. was it the actual know, or objective, what should he known? What standard did Pavlovich majority employ? Probably subjective. 3, the Pavlovich majority viewed the defendant's website as passive because it merely posts. Actually, it's a little bit of both because, I mean, honestly, the licensing body wasn't formed yet when the code was posted. So, yeah, he should have known only if the organization was formed. Although it sounds like it was engaged in licensing, otherwise it wouldn't have been out there. But regardless, it was a little of both that the majority applied. So the Pavlovich majority, this is 3, view the defendant's website as passive because it merely posts information, has no interactive features. The dissent also agreed that the mere operation of a website cannot expose the operator to suit in any jurisdiction where the site's content may be read. How is the determination of whether the website is passive relevant to the application of the effects test? We're talking about internet contacts specifically when we talk about the passive test, and that's on the low ends of the sliding scale. So the effects test is the Calder test, which is not the same as the internet contact sliding scale test, unless it's to be, and it sounds like this court read it from that lens. It was like a 2-part test, honestly. And Calder's effects test was like the overlay. So the Pavlovich majority viewed the effects test question as close, yet did not consider whether California's assertion of personal jurisdiction would comport with fair play and substantial justice in light of the Supreme Court's statement in Burger King. So Burger King stands for fair play and substantial justice now. That these considerations sometimes serve to establish the reasonableness of jurisdiction upon a lesser showing of minimum contacts than would otherwise be required was the majority's failure to consider the reasonableness of California's jurisdiction and misapplication of the due process requirement. In contrast, did the Pavlovich dissent place too much weight on the reasonableness factors? Now, we're going to end there because that's the end of the case notes.